Thank you.
Sorry.
Yes, Professor Opong, thank you so much for joining us. I think you're the last to welcome to I wanted to say that we are pressed for time, but please do not feel pressured at all to give your keynote, and we'll move on from that after. Thank you.
That's fine. I've been sitting here, so I'm okay.
Thank you.
I think Abu told me he was logged off. He's trying to join again, and he told me he called Olanio. Professor Olanio is trying to connect. Okay, he's connected now. Great. That's Professor Olanio, yes. But Abu is trying to connect again. Greetings, my Lord, Honorable Justice Aburo. It's nice to have you.
I'm very well, thank you. How are you doing?
Yeah, I'm very well, thanks.
It's good. It's good to be here.
Yeah.
Excellent. I think we're now complete, and I'm hoping that I can be heard by the audience. So it's 3 minutes past 5, but we're doing okay. Good evening. My name is Onyoja Momo, and I am delighted to welcome you all here today. I am addressing you as the chair of the Nigeria Group on Private International Law. You may have noticed that most of my NGPIL colleagues and I are dressed in traditional outfits. This was by choice. though most of us are a part of the diaspora or live abroad, I hope you will see that we embrace our vision as strongly as we do and will convey it in as many different ways as possible to get your attention. However, I have a disclaimer. What I am wearing today was gifted to me by a dear friend when I visited Accra, Ghana last month. So if you were all unmuted, I've no doubt I will hear gasps across this virtual room. But surely it is true what they say, Nigerians and Ghanaians, we're neighbors, brothers and sisters, so no hard feelings. So I say again, good evening. I'm delighted to welcome you all here to the inaugural event of the Nigeria Group on Private International Law. Tonight, we'll launch a new initiative that will bring together a small group of individuals with an important ethos: the promotion of private international law in Nigeria. The drive and the commitment of the group is embedded in the vision that our role is to serve and to harness our knowledge and skills in a collaborative way to inspire a progressive private international law system for Nigeria. As early career academics, but also qualified lawyers, some practicing, including myself, and already involved in various individual engagements and advocacy for private international law generally and for Nigeria. This is a purposeful stride towards turning that vision into real change. I say it with unreserved confidence. The group is not an exclusive self-serving club. The idea is that there are a number of individuals I have had the honor of crossing paths with who hold the same vision that I do. That is all. So may I at this stage thank the many participants in our audience today who have expressed an interest in membership, even though this isn't quite the aim, but your enthusiasm to support and offer your expertise is very important to us and to the future. The group includes Pontian Okoli, Chukwuma Okoli, Chukwudi Ojegbe, Abu Yakini, and myself, and you will hear from all of us later this evening. Our profiles and more detailed objectives of NGPIL can be found on the Conflict of Laws website announcement or on LinkedIn. I am pleased to say that there are currently no regrets from my colleagues to receiving my email one fateful October evening last year, when I suggested in no uncertain terms that we needed to join forces and get things moving. So we've managed to convince ourselves, to convince each other that we can get somewhere. Last month, Niger became the latest signatory to a Hague Convention, amongst the few in Africa. Earlier this month, I was in Accra. My visit was kindly hosted by the head of the Central Adoption Authority, Stephen Dombo-Tike, under the auspices of the Ministry for Gender, Children and Social Protection, Ghana, of course, is a signatory to the 1993 intercountry adoption, and you'll hear a bit more about that later. So much convinced we are, of course, indeed, and with a new lease of encouragement from recent events, that in due course, the how, who, and what will become more apparent to us where Nigeria is concerned to secure similar progress. So as a group, we are based in various parts of the world now and cover all 3 time zones in your program. But the duality, I say, the quality of this duality, we say, is vital, as is our connection to Nigeria. We want to bring our talent, energy, and skills to connect the right people, knowing that at arm's reach are some very distinguished experts that can assist on this venture, many of whom are in this virtual room today. Welcome. Many of whom the group have had the privilege of studying under and working alongside, including myself. So yes, there are established international frameworks and regimes within Nigeria's domestic laws and other bilateral treaties. But I am hard pressed to find a convincing narrative that these are adequate and sufficient to meet the demands of our cross-border realities in the field of private international law. Where international family law is concerned, it often comes down to the weight that one attaches to an order for maintenance sought by a parent living abroad, or the recognition of a divorce, a foreign divorce, so that one can remarry or seek financial remedy, or a foreign adoption so that an orphaned child can move to live freely with his or her adopted parent, have a future that is safe, secure, and free from exploitation. So if the debate is that the key international frameworks created by the Hague Conference are not necessary, and that this group's quest is but a fool's errand, then let's have a conversation about that. If the issue is not so much the desirability or the necessity, but the feasibility of adopting these frameworks into Nigeria's system, then let's also have a conversation about that. We have had many support from many that I cannot begin to thank, from the Hague Conference to many Nigerian judges and academics who have shown encouragement, to exchanging WhatsApp messages with Supreme Court Justice Makumi in South Africa, whom I met last year in Cape Town, to the Nigerian artist who kindly agreed to the use of his photographs that features in this flyer, to my Chambers' director, Claire, who's here tonight. And speaking of which, the tired but nevertheless quite important announcement, this webinar is recorded. Claire is keeping an eye on questions or raised hands, and if all goes well, the idea is that when the time comes, you will be visible, so visually and sound, to convey your comments, questions, and points to the panel. And so I hope this plan sufficiently takes us through a smooth evening. Now, this evening's event would not be quite the same without the support of our distinguished speakers and moderators. Goodness, graced with the presence of the Secretary General of the Hague Conference, Dr. Christophe Benasconi. No one better placed to present on the work of the Hague Conference and PIL and the vision for Africa and today for Nigeria. As Secretary General, he's focused on the good governance and strategic development of the Hague Conference, spearheading efforts towards its universality and inclusiveness. He's involved in numerous normative projects and non-normative activities of the Hague Conference, covering the full range of its mandate from transnational litigation and legal cooperation to international family and child protection law, as well as commercial and finance law. Our keynote will be delivered by Professor Richard Opong, no one better placed to present on reforming private international law in Africa. Professor Opong is the author of Private International Law in Commonwealth Africa and co-author of PIL, Private International Law in Nigeria, along with our NGPIL colleague, Chukwuma Okoli. Professor Opong's expertise in this area is second to none. He is an associate professor at the University of Bradford with an accolade of fellowships and memberships in the arts and science and law, masters in law from Harvard, Cambridge, and the University of Ghana. He has taught at and worked for several academic institutions and of course has written extensively on this subject. Thank you both. This evening is then divided into two sessions with details in the programme, which you can also see in the virtual chat room. The focus, of course, will be on the conflicts of law in Nigeria and the feasibility of ratifying the Hague Conventions, looking at civil, commercial, family, choice of law, and so on. In addition to hearing from myself and my NGPIL colleagues, we will also hear from Ignacio Gocochea, who is the representative of the Regional Office for Latin America and Caribbean, ROLAC for short, as part of the Permanent Bureau of the Hague Conference. Because the vision, of course, cannot be complete without seeing what it would look like in practice from the perspective of a decorated expert in the field. He has been recognized for his service as representative of ROLAC and for his dedication to improving the worldwide implementation of the Hague Conventions. Finally, I am indebted to our moderators who will facilitate the sessions this evening. For session one, Dr. Iyabode Oguniran. We first met on a panel in London in 2015 or 16, discussing child rights and the Child Rights Act in Nigeria. We've shared several platforms since and exchanged ideas in international family law. Dr. Oguniran is an associate professor at the Faculty of Law, University of Lagos. She's an expert in child law, has led a collaborative research on child justice in Lagos State, worked with UNICEF, Coram Children Legal Centre, and has recently set up the Anti-Trafficking Legal Hub for Lagos in the faculty. For session 2, we will be moderated by the Honourable Justice Habib Abiru. He is a Justice of the Nigerian Court of Appeal, having previously served as a High Court judge and as a practitioner before that, as well as former academic at Lagos State University, specialising in private international law. And closing remarks by Professor Hakeem Olaniyan, former head of Department of Jurisprudence and International Law, who has contributed immensely to the development of Nigerian PIL scholarship. Thank you all. And so, as they say, without further ado, may I invite Dr. Berlusconi, Secretary General, to the floor. Thank you.
Good evening, good afternoon, and perhaps even good morning, I don't know, depending on where you're joining from. In any case, a heartfelt welcome from The Hague. And thank you, Dr. Onyoyamomo, for your kind introduction. On behalf of the Hague Conference on Private International Law, the HCCH, as we like to call it these days, I have the privilege to present a few remarks to open today's proceedings. First and foremost, I would like to thank and indeed congratulate the Committee of the Nigeria Group on Private International Law, not only for having organized today's inaugural event, but indeed for having envisaged and commenced such an important initiative. The work of the NGPIL will certainly be of great significance to the promotion and development of private international law across Nigeria. While its focus may be national, the group's aims and activities are sure to inspire even beyond Nigeria's borders, highlighting the relevance of the discipline for other nations in the region, across the continent, and even beyond. It is this same relevance that continues to drive us at the HCCH, because the world of today is, as I often like to say, a world of private international law, a world in which every single day, literally billions of people around the globe are engaged in cross-border interactions of sorts, for their relationships and families, for work or study, for business or pleasure. The HCCH works to facilitate these connections, transactions, and interactions for individuals, families, and commercial operators across the globe. Indeed, the legal framework established by the HCCH conventions sets uniform global standards in cross-border family relations, judicial proceedings, and commercial activities, increasing legal certainty, promoting access to justice, and strengthening the rule of law. The HCCH conventions achieve this in a number of ways, including through legal cooperation mechanisms, specifically designed to bridge the gap between different legal traditions, while respecting the diversity of national systems, an approach that is of particular relevance in the context of a continent as vast and as diverse as Africa. As the only international organization working for the progressive unification of the rules of private international law at the global level, I believe that the HCCH has a responsibility to encourage the involvement of as many countries and regions as possible in its work. Universality and inclusiveness, thus, are central tenets of the organization's operation and enshrined as pillars of our strategic plan, demonstrating that strengthening the HCCH's ties with states throughout the many regions of Africa is essential to the strategic development of the organization. Unfortunately, too many African states are currently underrepresented in the work of the HCCH. Currently, only 8 African states are HCCH members. And there are another 20 or so African non-member states that are party to at least one HCCH convention. Nigeria is not yet among them, being neither an HCCH member nor a party to any HCCH convention. Though with the largest population and highest GDP in Africa, Nigeria undoubtedly has a key role to play. Working to address the lack of visibility and relevance of the HCCH on the African continent remains a high priority for me as Secretary General. I am therefore particularly enthusiastic about initiatives such as the NGPIL, initiatives that seek to increase the visibility and raise the profile, not only of the work of the HCCH, but of private international law as a whole. I hope that today's event marks the beginning of long and fruitful cooperation between the HCCH and the NGPIL as part of a collaborative effort in pursuit of a common goal for the benefit of all, ensuring that the Nigerian voice is being heard within the HCCH, that we can benefit from your expertise to ensure that your needs are being addressed in future work of the HCCH, and that through Nigeria's voice, the voice of an entire continent is being strengthened. Which brings me back to today's event. The NGPIL committee has done a tremendous job in securing many accomplished speakers, building an impressive array of topics into the program. I'm very much looking forward to hearing each of the experts' contributions, including, of course, that of our distinguished keynote speaker, Associate Professor Richard Opong. And so, without further ado, I would like to wish us all a successful event full of productive discussions. And I look forward to engaging with you all on these and hopefully many more such topics in the future. Thank you very much again.
Thank you very much, Dr. Bernasconi, for that opening remark. I will move on straight to you, Professor, Associate Professor Opong. Thank you.
Thank you very much. I'm very grateful to the organizers of this inaugural event for inviting me to give the keynote speech. My brothers and sisters, I think this is an exciting time to be researching private international law in Africa. In a recent article in the Journal of Private International Law, I noted that it's no longer accurate to describe private international law in Africa with refrains such as there is dearth of literature or that the subject is underdeveloped. We have now significant body of literature and case law, and the formation of this group is another exciting addition in my opinion. But these exciting developments should not blind us to the fact that there are significant issues with the private international law regimes in African countries that need systematic attention. Private international law in Africa can and should continue to grow, develop, and be reformed through legislation, incremental judicial development of the common law, the work of scholars, and greater engagement by governments with international legal processes, such as that of the Hague Conference on Private International Law. The need for such reform and development, in my opinion, is more urgent than ever. And the case in point is the agreement establishing the African Continental Free Trade Area. As some of you may know, the agreement seeks to create a geographic zone where goods, services, and capital will move freely among member states. And when we think of trade barriers, our minds often turn to the usual suspects, including tariffs, quotas, export and import bans, and technical barriers to trade. However, as private international law scholars, we know that the rules for resolving cross-border commercial disputes and managing cross-border commercial and indeed personal relationships can also be significant barriers to trade. And when properly attended to, the same rules can also play a facilitative role in advancing trade liberalization and factor mobility. The existing national laws on cross-border commercial dispute resolution need reform if they are not to become barriers to trade under the African Continental Free Trade Area Agreement. Happily, I think several countries have already undertaken reform, which are significant. So for example, Kenya, Zambia, and Zimbabwe, the recent reforms on their law on secure transactions have included choice of law rules, which are very significant. Ghana and Zambia have also introduced new corporate insolvency legislation. And in those legislation, they attempt to address the cross-border issues that sometimes arise. And since 2017, Angola, Ethiopia, Seychelles, Sierra Leone, and I think Sudan have all become parties to the United Nations Convention on the Recognition and Enforcement of Foreign Judgments. As scholars, we have often emphasized the importance for private international law regimes to respect jurisdiction agreements, arbitration agreements, and choice of law agreements. In other words, respect for party autonomy. And in this regard, we can say that some of the existing statutory reforms have been controversial. So for example, recent legislation in Tanzania dealing with natural resource extraction provide that disputes relating to them should be adjudicated by the Tanzanian courts and in accordance with Tanzanian law. Similarly, in recent legislation in Ghana and Tanzania dealing with private partnership agreement, they contain express provisions that such agreements should be governed by national law. And in other African countries such as South Africa and Namibia, and indeed Tanzania, we see a retreat from international arbitration through legislation. In my opinion, all these raise questions about the extent to which reform of private international law in Africa should be inward or outward looking. That said, I think there is no gainsaying that the exaltation of party autonomy in private international law discourse and jurisprudence sometimes collide with the demands of national development in African countries. For example, there are several African countries that have become saddled with huge arbitration awards because of foreign arbitration agreements that they've entered into. And others have had their constitutional norms displaced by the application of foreign law. I argue that as we advocate for reform of private international law in Africa, we should not forget that the subject is not wholly neutral. It has significant economic, social, and political dimensions. For example, in one English case in which a liberal basis of indirect jurisdiction was argued in terms of the enforcement of judgment, Lord Collins clearly responded that the introduction of judge-made law extending the recognition and enforcement of foreign judgments would not only be detrimental to UK businesses, but it won't also have any corresponding benefit. In other words, domestically informed cost-benefit analysis should not be avoided when we start thinking about reforming the private international law regimes on the continent. At the same time, private international law in Africa should not be insular. There is need for greater engagement of African countries with international legal processes relevant to the subject. There's clearly the need for greater collaboration between African countries and the Hague Conference on Private International Law. This is necessary to ensure the continuing development and reform of private international law in Africa, especially in the fields which have commercial significance and also in the fields of family law. There are several important subject areas such as the enforcement of judgment, choice of law, and jurisdiction agreements, where the work of the Hague Conference can be very useful to African countries. And we've already been told since 2006, a number of African countries have become members of the Hague Conference, but now that number is very, very low. I would definitely encourage this group to make it as one of your paramount goals to advocate for Nigeria to become a member of the Hague Conference. I think that will certainly open up the possibility that other African countries will join, given the weight that Nigeria carries on the continent. As I noted earlier, at present, there's a significant body of scholarly work on private international law in Africa. Leaving aside the numerous articles in the specialist journals, chapters in edited books and encyclopedias, and the doctoral theses that have come up, we also have several monographs that have been published. And this expanding academic interest definitely bodes well for reform of private international law in Africa. Writing in 1981, Professor J.C. Smith identified two principal ways in which academics can participate in law reform. These are through published writings and official bodies such as national law reform commissions and unofficial reform bodies, including those formed by the academics themselves. To these, I will add the potential influence of academic writings on judicial decisions. Indeed, in the advanced common law jurisdictions, the days when publishing in academic journals were largely for the edification of the writer and other academics are long past. Judges in those countries now frequently refer to academic writings in their deciding cases. The culture of judicial citation of academic work is, however, not yet fully developed on the African continent, with the exception of perhaps South Africa. Apart from the occasional references to old editions of what is now Dicey, Morris, and Collins on conflict of laws, one seldom finds citation of academic work in the conflict of laws decisions coming from the African court. It is hoped that they will develop with time a more enlightened approach from African judges that recognize academic writing as a viable, non-binding source of the common law. Clearly, this would be facilitated if African judges should start to read academic articles as part of their ordinary judicial activity. To facilitate this, I think we as scholars of private international law in the African countries must ensure that our writings are more accessible to legal practitioners and judges on the continent. In addition to books and articles, short case comments and reviews will also be important in this regard. We should certainly not be content publishing in foreign journals with foreign publishers. We should be very proactive and make sure that our scholarship is accessible in the countries which we research on and in Africa in general. This may mean sending your published papers directly to judges, to lawmakers, other academics, policymakers, and so on the continent. Finally, I think we should seriously consider coming together to work on projects aimed at reforming the subject in Africa. This will be especially useful given there is currently no official initiative to reform or harmonize the rules of private international law on a continental or regional level. Comparatively, we know that scholarly initiatives have played a significant role in legal reform in other regions of the world. So for example, there's the Asian Principles of Private International Law, which is the product of a group of scholars. And also in the Caribbean, there's the Model Law on Private International Law, which is being developed by a group of academics. Of course, in Africa, we know the work of the Research Center for Private International Law in Emerging Countries, which is based at the University of Johannesburg and led by Professor Niels. Its principal object is the drafting of the African principles of commercial private international law, I will certainly recommend that the Nigeria Private International Law Group start seriously thinking about a similar project in collaboration with the center or independently, but certainly some discussion should go on in that regard. Once again, I thank the organizers for inviting me. I'm certainly delighted to see the growth of private international law on the continent. And I think this group will have a very critical role in putting the subject on the map on the continent and certainly around the world. Thank you.
Thank you, Associate Professor Opong, for this, for your wonderful keynote speech. I'm most grateful to both our speakers at the start of this event, and we'll move on, if I may, to Dr. Ogunniran to open session one. And there will be time for questions, of course, which will be put to everybody on the panel in due course. Dr. Ogunniran, thank you.
Okay. Good evening. I hope you can hear me.
We can, yes.
Okay.
Good evening.
Okay. So good evening, the chair of the Nigerian Group on Private International Law. And I will also say good evening to the Secretary of the HECH. Permit me to stand on existing protocol so that we will not waste time. So we go into the first session, and we have three presenters. We have the first one is the prospects of ratifying a convention in Nigeria in comparative interrogation. And the presentation will be done by Dr. Potian Okoli. You'll be talking about the possibilities of ratifying, the convention in Nigeria, the opportunities and the challenges. Then the second presenter will be Dr. Oyonja Momo, and she'll be looking at the specific 8 conventions that we're talking about so that we all know the conventions, at least, even if it's an introductory part, and the protection and what they can actually offer to any country at all. Then the last presenter will be Mr. Ignacio Goshia, who will be looking at lessons learned from Latin America and the Caribbean. And it's very interesting because I've looked at it and I've seen that more than 10 countries in Latin America are parties to the Hague Conference. So I'm sure that we have a lot to learn from you on what we can actually do in Nigeria and how we can move forward to have these conventions ratified. So in that order, we take the presentations. Thank you. Dr. Potian, first, please.
Okay, can you hear? I think you can hear me now.
Yes, we can hear you.
Okay, well, thank you so much, Dr. Ogunniran. Thank you to everybody who has made the time to join us today on this occasion. Thank you so much. Now, let me quickly just say at this stage that I've avoided any technical distinction, at least from the Hague Conference's standpoint, between ratification and accession. Since Nigeria is a primary audience. So I will use the terms sign, of course, merely signifying an intention to become a party to a convention without any obligation, and then ratify, of course, which establishes the legal obligation through the country's relevant legal process. First, the context and parameters, and a lot has been said already about the context, and there will be no need to belabor the points. So I'll just quickly, go to the main issue. The main issue is that Nigeria is not a member of the Hague Conference. We know that, hasn't signed up to any treaty, and of course hasn't ratified any. What are the parameters I'm interested in? First, there are three possible levels of analysis. You could look at Nigeria vis-a-vis other African states, and that has already been hinted. The fact that there are countries in Africa which are either members or which have been proactive in adopting and using Hague Conference conventions. Or you could also look at Nigeria vis-a-vis non-African states, who are also very important members of the Hague Conference, but who have also adopted a similar approach of, one, either being members, or two, simply just adopting conventions almost on a case-by-case basis as they choose. The third possible level of analysis will be subject matter. And as I progress, I will be looking at each of these levels of analysis in that order. An important point, I think, and this is central, is the question of effectiveness. Now, I think the two questions of why and how are actually very pivotal to our current undertaking. And these are foundational. Now, the African Continental Free Trade Agreement itself has become paradigmatic of many things that have gone well for Africa, and that is true, and that must be encouraged. And in the same breath, I think the African Continental Free Trade Agreement also has indicated the prospects of Nigeria trying to engage with that question, why? And I say this because there was initial reticence on the part of Nigeria, we all recall, in ratifying the African Continental Free Trade Agreement. It was a late member, came very late to the table. But what I think is that process did show that Nigeria perhaps is beginning to engage with the fundamental question of why. Because even though it was frustrating that Nigeria was late to come to that table, what was encouraging was that the government actually suggested reasons for delaying, which shows that they were actually thinking about the implications of signing up to a treaty. And I think that's really important. I think it's a foundational aspect of trying to develop our laws, and it's important that we think of why we want to be a member of the Hague Conference, or why you want to use Hague Conventions or whatever. It's important to engage with the question why. But there's been also so much emphasis on that ratification process, and it's probably fair, because if you don't get past that stage of signing up to treaties or ratifying, then you can't do much, can you? But I think that there's been less focus on the institutional capacity. And I think that's something which there will be space to explore further. The law is quite settled in many countries, including Nigeria, on the process for ratifying treaties. The constitution is very clear, and there's been Nigerian Supreme Court guidance. So there's no question that it's not an issue how it's ratified or what we need to do and all of that. But there is more scope for debate as to the things that need to be done in terms of institutional capacity. If you do not merely want to tick the box, and you actually want the treaties to have functional effect in Nigeria. And I have a slide saying outside in or inside out, and what I mean is, looking from the outside, it's clear that you have the advantages of unification of private international law rules. I mean, after all, that's a core aim of the of the Conference on Private International Law, the progressive unification of private international law rules, which is fine. Now, looking from the inside to the outside, there are benefits in principle, and we know that. We know that it's important to sign up to treaties because there are advantages you could get from that. And you see on the right, I have a revolving door, and I'm thinking maybe it's not just about looking in or looking out. There's no guarantee that when you look in or look out through a window, you can see the full picture. So maybe what you want to look at is the benefits and institutional capacity, and see how in the long term that could actually lead to some sort of effectiveness. some of you may recognize that quote is a former American president, President Adams, who referred to America as a nation of laws. And I would say Nigeria is a country of laws, but it's also a country of many laws. So I make bold to say a major fact is that Nigeria hasn't been weak in actually having laws, but it's also fair to say that the major challenge has been implementing the laws and making those laws have practical meaning for people. Now, if we do go on to ratify Hague Conventions, and there's a strong case for that, you will extend that already very long list of laws. So it's therefore very important to engage with the question of what we do with the laws. Are those laws that we can actually make effective in a meaningful way to us, or are those laws that will simply sit there in much the same way as there are several laws, which we don't think perhaps are serving the functions which originally they set out to achieve. And you have that except there, and I don't mean to steal any of Onyoja's thunder, because I'm sure she will talk about this in a moment. But you see that except there, what it does tell us is one of the institutional weaknesses we currently face. And what has happened is that we've had from March or thereabouts, Nigeria has been added to the blacklisted countries in Scotland. Now that decision was based on evidence received through international processes, through the central adoption authorities, and unfortunately Nigeria is blacklisted, and that's a problem. Now, you can place that side by side with a very popular area, foreign judgments. And the reason I use the ECOWAS framework is that it's something we can relate to. It's something that is very much within our reach. And we can ask ourselves how we have fared in terms of the institutional capacity and building. And that's another excerpt there, and that's from the president of the ECOWAS court. And that's not in terms of the enforcement of judgments. And this analogy is really important because the ECOWAS treaty has the functional equivalent of the treaty obligations which we would have if we were to ratify ratify Hague conventions from the Hague Conference. But it's not necessarily Uhuru. It's not El Dorado at all. And it's important that we think of the institutional capacities. This is our own treaty. This is a regional treaty. And there are major questions to be asked. There's a very recent study as recently as February this year that says probably up to 25 judgments of the ECOWAS court Nigeria has not complied with. And the question is, well, it's not a very pretty narrative. So it's something which we need to think and reflect and ask ourselves. We need to build that capacity. And I say this because a good number of those judgments, they are not controversial judgments. They are not, many of them do not have political underpinnings. They are, sometimes they are basic human rights related judgments. Somebody is retired, a government official, somebody who grew old and needed to get his money back or something, and they're just not enforced. Some of them are not $6 billion judgments. Some of them are not $10 billion judgments. So we need to ask ourselves what we need to do in terms of institutional capacity building. There are a number of possible approaches. You could, in theory, accept all conventions. There's no precedent that actually says there's any direct correlation between being a member of the Hague Conference and ratifying all conventions. I think
Dr. Okoli, you have to be rounding up now.
Yes, and I am.
Okay.
Yeah. And on the other hand, there's a traffic light system, or you could join as a member and you could select your conventions on a case-by-case basis. Or you could decide, I won't join just yet, and I will select conventions according to our individual needs. These are all possibilities. But the important thing is we need to engage with that process. We need to ensure that we'll be looking at the effectiveness of the treaties rather than simply just going about things without a careful articulation of the implications and how those treaties can come to full effect. And that's where I think we're getting it right, and I think the future is bright. Thank you very much.
Thank you very much, Dr. Okoli, for that exposition. And I will also join you and say that I think the starting point is to always look at the fact that Nigeria is a federal country. And even if the president ratifies a treaty, you still have to bring it before the National Assembly. That is number one. Is a big problem with all the state houses of assembly. Two-thirds majority must approve. Then the second issue that when you're talking about issues concerning children is on the residual list. So even when you adopt at the federal level, the states still have their own discretion whether to adopt it as their law or not. So you have all those issues there, and it becomes very difficult. The Child Rights Act faced the same problem. So before we now even start to talk about implementation.
Absolutely.
Anyway, thank you for your exposition.
Magic, thank you so much.
Okay. Okay, you want to make a comment? Okay, let's quickly go to Dr. Oyonja Momo for our presentation.
I think my screen has been shared.
Yes.
Excellent, thank you. I'm going to do my best with timekeeping. Last year, I wrote an article for the Africa Porter's Expert Analysis Hub, and I liked the image that they used for the article so much that it forms the backdrop for my short presentation this evening on the Hague Family Law Conventions. This is all you will see. Now, of course, it is no secret that the Hague Conference has for some time now sought to promote the implementation, particularly of the Children's Conventions or the Family Conventions in Africa. And this was reiterated at the Africa Regional Conference that was held in April of 2019 at the University of the Western Cape in South Africa. And again at the 23rd Annual Family Law Conference in March of 2020 in Cape Town, which I was fortunate to have attended. Nigeria was represented at the Africa Regional Conference and would no doubt have absorbed the wisdom and the experiences of many countries, both Hague and non-Hague or non-contracting states, who were present. The conclusions and the recommendations of that conference reported that the participants affirmed their commitment to the principles upheld by the 1990 African Charter on the Rights and Welfare of the Child and the 1989 United Nations Convention on the Rights of the Child, the UNCRC. Indeed, Nigeria's Child Rights Act, as Dr. Ogunira has referred to, 2003 Act, is a comprehensive, and perhaps one could say pioneering piece of legislation with the utmost intention of strengthening the aim of the protection of children. So the 2003 Act upholds the principle of the best interests of the child being the paramount consideration in line with the UNCRC. And I say notably that the drafters of the 2003 Act were unafraid to tackle salient humanitarian issues such as child trafficking and child labour within that piece of legislation, if you review it. Now, I was scurrying around the internet to find out what was going on with the Ministry for Women Affairs and what was on their agenda. And in October of 2019, the ministry set out its goals at a meeting which was held at the National Council on Women's Affairs and Social Development. They set out a set of goals for reviewing and working progressively towards gender equality and social inclusion. The ministry explored key issues aligned to its mandate for eliminating all forms of discrimination against women and gender-based violence in Nigeria, but in particular, ensuring the implementation of the Child Rights Act. And a number of initiatives were considered, including a state child trust fund and adopting the He for She campaign to prioritise women empowerment, address the trend in child trafficking and the impact on women, children and other vulnerable Nigerians. So in accordance with the mission statement of the ministry and the mandate of that department, its very key objective was promoting and protecting children. With this in mind, the aims of the Hague Conference's family conventions and that of Nigeria's domestic laws surely align themselves. As summarized at the African Regional Conference in 2019, through the legal framework of the conventions, in quote, children will be protected across borders. Children who are victims of sale, trafficking, or abduction, children caught up in the international parental disputes between parents mostly, children who would benefit from financial support, who have endured improper placements abroad or are internationally displaced, unaccompanied, separated, refugees, children who have been subjected to unethical and unlawful inter-country adoptions. So the successes of the Hague Children or Family Conventions in unifying the rules of private international law in that area as a global solution, surely we say are unparalleled. So the list there you see, the family conventions are referred to on the right side of your screen. The 1980 Hague Abduction Convention, the 1993 Inter-Country Adoption Convention, the 1996 Convention on Child Protection, and the 2007 Hague Convention, essentially on maintenance. So African members, and I know Dr. Benasconi alluded to this, African members of the Hague Conference, and I think I've counted them right, but forgive me, Burkina Faso, Egypt, Morocco, South Africa, Tunisia, and Zambia. There might be others. States that have acceded to one or more of the children's conventions are Lesotho, Guinea, Benin, Congo, Cote d'Ivoire, Mali, Namibia, Niger, Rwanda, Senegal, Togo, Ghana, and Zimbabwe. And as we all know, Nigeria is not party to or a contracting state to any of these conventions. Now, whilst Nigeria continues to address key issues around women and children's rights through, for example, the National Agency for the Prohibition of Trafficking in Persons, NAPTIP, Nigeria remains on the Tier 2 watch list for trafficking in persons, and it is respectfully suggested or argued that implementing the Family Hague Conventions is now all too necessary and now long overdue. As my anticipated report on my visit to the Ghanaian Central Authority will show, acceding to the 1993 Convention, for example, will positively impact on the fight against the exploitation of children. Now, there is much ground to cover with these 4 conventions, and so I will focus really on the 1993 Hague Convention. Accession to the 1993 Adoption Convention would reinforce Articles 3 and 21 of the UNCRC and help prevent abduction, sale-off, or trafficking of children. The 1993 Adoption Convention seeks to promote and uphold the best interests of the child in the context of inter-country adoption and is also instrumental in the recognition of foreign adoption orders. As Pontian has mentioned, the blacklisting, if you can put it that way, in terms of adoptions from Nigeria is not just, it's not just in Scotland, in England and Wales as well. The same special measures were passed back in March. So as a non-contracting state to the 1993 Hague Convention, adoptions are not convention adoptions, nor are they afforded recognition in a straightforward way. So in the UK, an application to the High Court under the inherent jurisdiction for recognition of a foreign adoption is the only available route. And firsthand, I represent clients not just from Nigeria, but other parts of Africa in predicaments such as this. The benefits of Nigeria acceding to the 1993 Hague Convention are far-reaching. Firstly, it gives effect to the objectives of the UNCRC, which provides that the best interests of the child would be the paramount consideration. Secondly, it creates a cooperative or cooperation framework from the beginning, and it establishes minimum standards and safeguards through a uniform convention language that promotes mutual trust and cooperation. Last but not the least, it reduces the enormous emotional distress that I observe day after day when I do cases such as this, the expense, the delays, the instruction of experts, etc., and the uncertainty faced by all those concerned, particularly adopted parents and children who perhaps are separated until a decision is made. So for the Nigerian child, these issues are contrary to the welfare of that child and can, and I say must, be prevented. So to round up on the 1993 convention, when I visited the Ghanaian Central Adoption Authority last month, I was struck by the overwhelming positivity or the positives expressed.
You should be rounding up now.
I will. I was struck by the overwhelming positive expressions that was expressed by Stephen about the convention 5 years on. Ghana was on the watch list. He described it as, he used the word riddled, that Ghana was riddled with challenges and problems around child rights and children unaccounted for, children orphaned or abandoned. And essentially what happened was the Department of Gender, Children, Social Development, along with the Attorney General, got together and the offices of the heads of services came together and assessed the current child protection system in the country, providing two key recommendations. The first, establish a central adoption authority. The second, accede to the 1993 Hague Conventions. And to end, I think of course, the key was that the conducting of adoptions in a manner that promotes the welfare and the well-being of children and adopting relevant laws, including the Hague Conventions, would include a rigorous process. It's not without its pitfalls, delays, for example, in order to ensure effectiveness, and of course the issues of pre-Hague cases. But nevertheless, to end, in his very positive words, Stephen Dumbo-Tike expressed that ratifying, acceding to the 1993 convention was one of the best things Ghana could have done in terms of child protection and child development. And I hope that Nigeria will hear those words. Thank you.
Thank you very much for that presentation, Dr. Momo. And if I want to go into what is happening in Nigeria, we won't even leave this place. I looked at the Child Rights Act on international abduction, and there is a section actually prohibiting international abduction, but it just criminalizes it. That means that the process of trying to recover the child or to return the child is not clearly stated in the law. Then when you go to international adoption, you also have variations, because in the Nigerian Child Rights Act, the Act states specifically that prohibiting international adoption, that is only Nigerian citizens that can adopt children. But because it's a federal legislation, you now have states adopting. So I look at the child rights law of Lagos State, and that provision is not there. That section is not there. That means that in Lagos State, you can have international adoption. But the challenge is, you don't know the process. You don't even know whether those children are protected. You don't know whether they are protected at all. So I don't know about other states. I don't know the variation that you have there. And that is why I agree that if we ratify the Hague Convention, then that international cooperation is very important. You can have cooperation, then you can know the process is certain. So I will leave it at that, and then maybe I'll make my comments later on. Let's take the last presenter, which is Mr. Gokochia, for this session. Mr. Gokochia, please. Okay.
Thank you, Chair. Good day, good evening for everyone. Let me just echo my Secretary General's words in thanking the NGPIL group for this excellent initiative, which is so important for our work and for the development of PIL in Nigeria and in Africa. I would be delighted to share a few thoughts on what we have been experiencing in our regional work in Latin America, with the hope that some of these practices might inspire the important work you have ahead in Nigeria and in Africa. So let me start by saying that in Latin America and the Caribbean, we have basically two legal systems, civil law and common law, in particular the latter in Caribbean states. And of course, Hague conventions are suitable for both systems because they have been negotiated and implemented now and in practice by countries with these systems. So to start with a kind of a snapshot on ROLAC, let me say that the objective of this Office for Latin America and the Caribbean is to increase the visibility of the HCCH as an institution and its conventions in the region. In practical terms, we try to get more members to our organization and more state parties to our conventions. We also try to engage states in our ongoing work, so it is more inclusive and it's more legitimate, and therefore also it has better chances of being later on incorporated into the national systems. And we also try to improve the effectiveness. As one of the previous speakers mentioned, it is extremely important for the Hague Conference, not only for states to join conventions, but to implement them in a way that are really effective. So we try to develop all these tasks in Latin America and the Caribbean from this small office based in Buenos Aires. In this region, there are certain conventions that have broad penetration, in particular the Apostille Convention, followed by the abduction, the child abduction, the intercountry adoption. And we are currently seeing raising interest on the 2007 Child Support Convention and the 2019 Recognition and Enforcement of Judgments Convention. And we are also seeing an increased interest in memberships, and we have welcomed new members from this region in recent years. There are general challenges that we see in developing our work, and although several Latin American states have a long tradition in PIL, and there are well-known academics, scholars, and there is case law, there is still lack of visibility from in the public sector, in particular for decision makers, which is why we notice that it is not that common when it comes to the public sector to find experts in PIL. And we think that this lack of, let's say, political support and prioritization of PIL as such explains why it takes so long for states to join our conventions, which is certainly a challenge that we identify not only in Latin America, but worldwide. One of the challenges that we, HCCH, have to face and hopefully improve is the speed in which states absorb our instruments. We see some opportunities and probably linked with what Onyoya just shared on the Children's Convention, for example, that we should not just see these instruments as mere PIL instruments with technical complexities, but we should see them as a way of enforcing human rights. And the clear example is the implementation of the CRC, which is an obligation for any state party to the CRC. And there are several articles on this Human Rights Convention that can only be implemented through mechanisms provided by the Hague Conference, and we are talking now about the Hague Children's Conventions. I think it's also important to consider that in order to promote international business, something that decision makers are always interested is to generate the legal infrastructure that makes it possible. And here again, there are several Hague instruments that would facilitate this climate for foreign investment. So in practical terms, we think we have to develop adequate information for decision makers. Maybe not too technical, not just explaining a PIL instrument, but more practical, trying to explain why states are implementing human rights, protecting human rights, and promoting international business through these instruments. Therefore, we also think we need to encourage cooperation between the academic sector and the public sector, because as I just mentioned, it is not that common to find experts on PIL in state agencies. So let me share a few lessons that we can say we've learned in promoting the HCCH work at the regional level. First one, changes are made by people, and you are certainly making a change today with this new NGPIL group. And it is extremely important to identify champions and build trust with those stakeholders that may have a say in the incorporation of new conventions, and that they will benefit with the incorporation of those conventions, thinking about judges, lawyers, human rights advocates, child protection advocates, NGOs that promote international business, state agencies that are involved in any of these subjects. I've heard recently also about the capacity building. Of course, there is a need to develop capacity to deal with these instruments, and therefore it's always important to promote trainings for judges, professionals, public officers. We need to strengthen the public authorities, and in particular, ministries of foreign affairs, ministries of justice, AG's offices. They need to know about the benefits of these conventions and how they should implement them to make them effective. In this regard, let me share the experience of Mexico, Argentina, and Paraguay, who have not long ago implemented cooperation agreements between scholars and the relevant state authorities in charge of PIL. And we think that these are practical examples of how the capacity building could be strengthened by a good cooperation between the academic sector.
Rounding up now, Mr. Chair, you have to be rounding up now.
Okay, thank you. I think it's important to consider finally the political timing. There are windows of opportunities in states that we need to be ready to follow. Once we have these opportunities, we have to reach the relevant offices. Extremely important, the role of judges. Judges in Latin America have made really wonders in terms of promoting and implementing Hague Conventions in cooperation with their authorities. And finally, the importance of working with networks. We have developed networks of judges, networks of academics, networks of central authorities operating conventions, and national organs, members of the Hague Conference. So that would be our lessons learned. And last but not least, be patient. These are long processes. You need to be prepared to follow up, because things will take time, and you can count certainly with us to support this extremely important initiative. So thank you again for your time.
Thank you very much. Thank you for that submission. I can say that you have really said some things. You said that we need to increase visibility and that there is need for legal framework, which I really agree with you. And whatever we are doing, at the end of the day, we have to train our judges and our practitioners and see that they know everything about this convention. That is when it's eventually ratified and is domesticated. So that, but the most important thing now is to start to create awareness about the law and about the benefits. And I believe that is what we're doing now. So thank you very much for that elucidation. So on that note, I think we've taken the three presenters, and the floor is now open for questions and answers. If you just take the questions, then our panelists will help us to answer some of the questions. Okay, we have one hand raised up, Dr. Christopher. Maybe we
Madam
should
Chair,
take,
but,
I don't know, should we take all the questions, then the panelists will just discuss it?
I'm in your hands, Madam Chair, but if there are no questions immediately, I'm happy just to follow up with a comment.
Okay,
but I'm in your hands.
Okay.
And I simply wanted to echo the very important comment that has been made about capacity building and taking into account the reality in which we try to materialize all these efforts. And that takes me back to my point about inviting Nigeria to become a member of the organization. Of course, as a member, as I said, you can co-decide the work program. You are invited to official meetings. Your voice is being heard when it comes to negotiating new instruments. You can make sure that your needs are being addressed in these discussions. But practically speaking, one of the most significant advantages of being a member of the HCCH is that you have priority access to technical assistance. So if you need support from the HCCH, either from the PB or through cooperation with third-party experts, you are far better off being a member of the HCCH, because we at the Secretariat, we receive so many requests for technical assistance that we have to prioritize them. And the very first basic criteria that we apply in prioritizing these requests is to address our members first, which I think is a perfectly understandable and logical choice to make. So if this important principle of capacity building, making sure that government officials, practitioners, judges, obviously, users and operators of the conventions are being trained properly, I think membership is a key issue to consider. In addition, of course, to all the other advantages that come with it. And maybe just a quick response also to another comment made by Dr. Okoli. You don't need to look at all the HCCH conventions. Please don't. You know that there are 40 conventions on and other instruments on that list. You can easily disregard half of them. And I say that very openly and very bluntly, because some of them are old, some of them have just not been successful, some of them have been replaced by more modern instruments. Focus on what is important, what is actually working in practice. And I'm talking here about a good dozen or so of conventions. Interestingly enough, most of them established cooperation mechanisms between states to ensure a proper enforcement of key principles, such as effective protection of the best interest of a child across borders, or effective cooperation between states when it comes to service of process or taking of evidence or recognition of judgments, what have you. So make a list of what is important, what your officials and supporters can effectively put in place and apply, take it step by step. But these are important principles to keep in mind. Thank you, Madam Chair.
Thank you very much for that comment. We will take Professor Beaumont. Professor Beaumont, please, your question.
Yeah,
or
can
probably
you hear me?
A comment. Okay.
Can you hear me?
Yes, we can hear you. Please go on.
Yeah, thank you. I just wanted really to commend the organizers of this group for the initiative. I think it's excellent that this group of relatively young academics and practitioners from Nigeria, several of whom I know quite well, having been involved with supervising or reading their work. And I think it's fantastic that you've managed to start with such a distinguished event and have brought Christophe and Ignacio into the discussions, and of course Richard with his amazing expertise on African private international law. All I want to say is please continue your hard work, even though I'm sure you'll find it difficult to persuade governments. I've spent a lot of my career trying to persuade governments who are members of the Hague Conference to do things, and even then it's difficult. So when you're starting from such a low base, as it were, with Nigeria not being a member and not being a party to any Hague Convention, it's clearly a huge undertaking. So I agree with Christophe, you need to make a kind of prioritization. What are the really the most important benefits for Nigeria in being in the Hague Conference, and which of the conventions are the ones that really are the most attractive and relevant for them to start with. And of course, I would just say, please look at the most successful conventions, because the more successful a convention is at the beginning, the bigger the benefit in terms of the number of states that will also be applying those conventions. So clearly child abduction and adoption on the family law side, and on the litigation side generally, clearly service and evidence are the ones that are the starting and building blocks, and we hope that will build out into things like choice of court and judgments, and also the Children's Convention and maintenance. But you know, I think the obvious thing to do is to persuade your government officials to invest in a few conventions, and indeed the benefits of membership. But I would perhaps urge to go with getting one or two conventions going first, and the more political thing of joining the institution once people see that there are actually some tangible benefits from conventions. Maybe that might be the way forward. But I'm not a diplomat, and that might not be the best way in Nigeria. I don't know enough of the situation on the ground, but it would be great if you could make those contacts with the key officials, whoever they are, in the relevant ministry. Thank you very much.
Okay, thank you very much, Prof. Olukayode Enitan, do you still want to ask your question? Kayode Enitan. Okay, maybe I can't see any other hand. Okay, no question. Okay.
I think Benga wants to ask a question. Professor Bamudu.
Okay, please go ahead.
I hope you can hear me.
Yes.
Okay, it's just a comment, really, rather than a question. First of all, as I'd like to echo the compliments to the organizers of the event, pioneering in its own way, and of course, leading or encouraging the discussion and the discourse on these very, very important matters. The bit I'd like to say, so it's a form of appeal to the Secretary General and the officials of the HCH that are here, as well as far as possible, the organizers. The dialogue with the officials in Nigeria in particular, just speaking from the perspective of Nigeria in particular, will be effective not only at the technical level or at the professional level of engaging officials and so on, but in terms of other events and activities, sort of awareness creating. They may be in form of seminars or symposia and things like that, but not too heavy-handed, but rather aimed at demonstrating the practical benefits of some of the important conventions that we're talking about, especially considering, as Dr. Ogunira said, that Nigeria has particular problems with regard, for example, to the Child Rights Act, and having both state legislation and federal legislation with potential conflicts and so on. These are things that we need to engage with, well, we need to engage the relevant officials in the manner that is most effective, that will make them pay more attention. That's just a simple point I wanted to make. But thank you very, very much once again for the event itself, and of course for inviting me.
Okay, thank you for that addition, Mr. Gbega Bamodu. And I think in going forward, what will actually help is to probably also gather statistics. I was surprised that as at in 2019, if you go to the United States statistics on inter-country adoption in Nigeria, Nigeria has the largest in Africa, 116, compared to 7 in South Africa. So if you have that that kind of statistics, and you can really use it to determine that this is the situation that we are facing currently. This is our cross-border, experience. Even when you are talking about international child abduction, we have it all the time. If you are talking about maintenance orders in respect of maybe parents that are separated and one is living abroad and the other one is in Nigeria, I checked. The only law you could see is the Matrimonial Causes Act of 1970. So if we get statistics like this and we can show them that these things are really happening in Nigeria, we have problems. And when we accede to this convention, what will happen? There will be international cooperation. There will be process, there will be certainty. Then if you go from that angle, maybe it will be making sense. But if we are just telling them about the benefits, at times they won't even see it. But when you go with statistics, they will know that we have these realities in Nigeria. So on that note, I think I will just give the panelists maybe one minute to round up so that we can go to the next session. We'll start with Dr. Okoli. Just 1 minute, maybe a closing thought or something.
Yes, thank you so much, Dr. Ogunera. I think you have done such a fantastic job so far. Thank you. And thank you for being so punctual, keeping us on our toes with the timing. So, can I just say thank you once again for all those who have contributed. I just want to quickly add, Dr. Christoph Benascone, you mentioned the need to prioritize. I think Professor Beaumont said that as well. I absolutely agree. In fact, on that slide, if you notice, I had the option of possibly engaging with all the conventions in red. So I used the traffic light system, and that one was deliberately in red because that was a bad idea. And the other one was amber, because there's a possibility of going on case by cases according to priority. But Dr. Benascone, can I just quickly ask this question? And I know there's so much the Permanent Bureau has done over the years. You can go back to the 70s to see efforts that have been made in post-convention support. But in addition to the things you've said, including trying to encourage state Nigeria to join and to participate, is there any other possible way, perhaps pre-convention support can be given? I know you've mentioned a number of them, but can you think of any other way to sort of, get such states really on board and saying, look, this is something you can do and you want to do?
If I may, Madam Chair, just responding directly. Yes, my comment should not be understood as meaning you can only get any form of support by first becoming a member of the organization. We can absolutely envisage a situation where we can organize, 1 or 2 seminars, maybe one on the core family law conventions, another one on the more procedural conventions, and I would include the Upper Sea Convention for the production of public documents abroad, simply because it is such a successful convention. But we can absolutely find, an opportunity to do so, in particular now that we have such an experience also with online events. But this can be done and should be envisaged. And I would be more than happy to look into such an option with the group and relevant participants from the different ministries and possibly judges also would be an important addition. Thank you.
Thank you.
Okay, Dr. Onyoja, your closing thoughts.
Well, just a thank you to all the contributions that we've heard. There is a lot of ground to cover, and clearly this is a lot in a very short period of time. I observe and I acknowledge comments made particularly about focus and pointing out what is our priority and what we want to do. And on my very venture to Ghana Central Authority, I hope that I've come away with a number of important points that were made by the head of the Central Adoption Authority as to how, because I was very keen to know from the inception how Ghana put it on the table, how they put the 1993 inter-country adoption as a matter for discussion, and obviously how it moved forward from that. Like Dr. Oguniran said, we are working together collaboratively, obviously individually, but also together with Dr. Oguniran and another academic at the Nigerian Institute of Advanced Legal Studies in Abuja, particularly on child protection, and as she says, trying to collate and put together information that will further strengthen what we want to say and how we want to hopefully persuade the Nigerian government and other relevant stakeholders. So, well, watch this space, I think, is all I can say. But thank you for all the support and encouragement. Thank you.
Okay. And finally, Mr. Gokochia.
Sorry, just a follow-up comment to the question of Professor Okoli on the pre-convention activities. I think it would be important, I'm sure I'm speaking for my SG as well, to consider that we are having now 3 big special commissions ahead, one on the apostille this year, one on the adoption convention and the child support next year. I think it will be extremely important if we can identify the relevant Nigerian authorities that might have a say in the incorporation of these conventions, so they can attend this meeting, hear discussions, see how states are doing. We can even liaise these authorities with the possible states so they can learn how they implement it, how is their experience working. And I'm sure the NGPIL group might also be involved in this, identifying and somehow coaching authorities to this global exercise, which I think are a very good first step towards the incorporation of these instruments.
Thank you very much. I think we should be closing this the first session now. Somebody asked how he or she can be an active member of the group. So that is for Dr. Onyoja. Maybe you just put an answer in the chat box.
I will, thank you.
On that note, we draw a curtain on the first session. Thank you very much. Thank you, panelists. Thank you, participants. Okay.
If I may briefly just introduce the second session, which is moderated by the Honourable Justice Abiru. I will simply pass it on to you, Judge, to open the session. Thank you.
Okay, good evening. Let me start by commending the chair and other members of the NGPIL for this initiative. It's a long due initiative because of the problem of lack of progress and development in private international law in Nigeria. I'm happy that this is happening now, and this initiative, there will be major progress made, at least in the local practice of the private international law in Nigeria. Now, this session has 3 papers. One will be by Dr. Chukwudi Ojiegbe, Seeking Recognition and Enforcement of Foreign Arbitration Awards in Nigeria. The second one is Dr. Abubakar Yakini, who will speak about jurisprudence of personal jurisdiction. And the third one will be Dr. Chukwuma Okoli, who will speak of choice of court agreement in Nigerian jurisprudence. Now, because of time, I will call on the first speaker. Yes. Sorry, someone said I was echoing. Am I clearer now? Yes. I mean, the problem was that I was having problem with the service provider. So I joined with two different equipment, different service providers, so as to not have problems with the session. Let me start by calling on Dr. Chukwudi Ojiegbe to present his paper. You speak for, I think, about 9 minutes because of time. 27 minutes, I will clear my throat to let you know that you have 2 minutes to go, and then you just stop. Dr. Chukwudi Ojiegbe, please, you have the floor.
Good evening, everyone. Can you hear me?
Yes, we can hear you.
So good evening, everyone. Thank you, my Lord Justice Abiru. And I would like to thank all the participants and everyone for making our time to attend this inaugural seminar. I'll share my screen, please, if you permit me.
Please go ahead and share your screen.
Okay. Can you see my screen, sir?
Yes, we can. We can see your screen.
Okay, the presentation today is just going to, I'm going to be talking about the recognition and enforcement of foreign arbitral awards in Nigeria. And obviously, just to align myself with what we've been talking on and the objectives of this platform, which my colleague, Dr. Momo, has perfectly articulated. So basically, the presentation is going to be divided into 3 parts. The first part is going to basically talk about brief introduction about arbitration. And the second part is going to talk about the methods of recognition and enforcement of foreign arbitral awards in Nigeria. Obviously, it's going to look at 2 main methods. One, which is under the Arbitration and Conciliation Act 2004, which incorporates the New York Convention on the recognition and enforcement of foreign arbitral awards. Also, I'm going to be talking about just briefly on the statutory regimes, which is the 2 main statutory regimes: the reciprocal enforcement of judgment ordinance Cap 175, laws of Federation of Nigeria 1958, and the Foreign Judgment Reciprocal Enforcement Act 1960. And basically, I'm just going to, the third section is going to be looking at, the difference in terms of the Arbitration and Conciliation Act and the statutory regimes. And then finally, I'm just going to conclude. So just a disclaimer, I will not be talking about investment arbitration. So I'm just going to be focusing entirely on foreign arbitration awards as it relates to Arbitration and Conciliation Acts and under the statutory regime. So basically, arbitration, as we all know what arbitration is, it's an alternative method of dispute resolution that parties obviously agree to. Nigeria as a country and the Nigerian courts have given effect to the concept of party autonomy, which recognizes the fact that parties are able to agree the content of their contracts and agree an arbitration agreement. And obviously, within very, very, very broad limits, the Nigerian courts recognize the concept of party autonomy and recognition and enforcement of foreign arbitral awards, given based on the outcome of the arbitration agreement. So the main PIL instrument on the recognition and enforcement of foreign arbitration awards is the New York Convention on the recognition and enforcement of foreign arbitral awards, which was signed into on the 10th of June 1958. Nigeria acceded to that convention in 1970, March 1970. Nigeria also made reservation with regards to reciprocal and commercial reservations, which basically means in terms of it limits the scope of the the New York Convention to only commercial matters, and also to other countries that apply the reciprocity context, in terms of the fact that if you recognize judgments given in Nigeria, Nigeria will accord you the same reciprocity. So the New York Convention, it's domesticated in Nigeria by the Arbitration and Conciliation Act, Laws of the Federation 2004, and that particular, I call it ACA for abbreviation, incorporates all the New York Convention articles. So what are basically the methods of recognition of foreign arbitral awards in Nigeria? The first one is the Arbitration and Conciliation Act, which incorporates the New York Convention. So basically what it means is that when parties enter into a commercial agreement and there's an award given, the judgment creditor can obviously bring the award before the Nigerian courts and seek to have it recognized and enforced in Nigeria. And the judgment creditor obviously will rely on the Arbitration and Conciliation Act, which gives force to the New York Convention. Now, the second one is the statutory regimes. So basically what the statutory regimes gives effect in terms of the fact that when a party, when there's an award given at the international level, for example, in the United Kingdom, the judgment creditor can take that award and have it incorporated or recognized by the British courts. And after recognition and after recognizing that award, then the judgment creditor can bring the award to Nigeria and recognize that judgment, which has already been recognized by the British court, and recognize that judgment under the reciprocal, I call it the statutory regimes, because Section 3 obviously gives effect, recognizes arbitration awards recognized by the foreign country as a judgment to be recognized in Nigeria as a judgment. Now, so basically, either a judgment creditor takes award and comes to Nigeria and recognize it as under the Arbitration Act, or the award can be incorporated as a judgment and then enforced in Nigeria as a judgment of that court. Now, obviously, I cited two cases in terms of the very recent one delivered by my Lord Justice Toby, the Emerald Energy Resources, which were delivered last week. Obviously, gives more depth in terms of recognition and enforcement, clarifies the Arbitration Conciliation Act and the recognition and enforcement under the statutory regime. Now, this obviously brings me to the main issue that from my perspective, I think there's an issue here with regards to recognition and enforcement of foreign arbitral awards as a judgment of a court. Now, the question here is the foreign judgment, which incorporates an arbitration agreement, truly a judgment to be recognized in Nigeria through the statutory regime? Because obviously, if you look at technically that particular judgment incorporating the foreign arbitral awards, that the court is itself, is not deciding on its authority, and also it's not deciding on the merits of the dispute. Now, the main issue here is that the provision under the statutory regime, for example, Article 6, provides grounds for refusal, which a judgment debtor can obviously use to refuse the recognition and enforcement of a judgment. And the Arbitration and Conciliation Act, Section 51 to 52, also provides grounds for refusal of recognition and enforcement of arbitral awards. Now, under the Arbitration and Conciliation Act, the grounds there are very exhaustive and very robust, in the sense that it gives the Nigerian courts the ability to raise the issue of arbitrability and public policy, on its own motion. And also, it obligates the judgment debtor to put before the court.
Dr. Chukwu, you have to round it up now.
Okay, he also obligates the judgment creditor to put before the court the original arbitration agreement and the arbitration, the award itself. But under the statutory regime, obviously, the grounds there do not give the Nigerian court do not provide the same fairness, or it's not the same. It's not robust enough when compared to the Arbitration and Conciliation Acts and the provision contained there with regards to refusal. So my key point is that is it not just a roundup? So basically, the question is it not yet time for us, because that particular, the statutory regime, if you look at the statutory regime, for example, the first one, the reciprocal enforcement, which is the 1922 ordinance and the 1960 Act, basically, we are done at the time before the New York Convention came into force, which was 1958. So, for Nigeria to continue to recognize foreign arbitral awards, foreign judgments incorporating an arbitral awards in this 21st century, I think we should, look at the way to obviously make the arbitration act more robust, in the sense that we should, perhaps amend that statutory regime to exclude the possibility of recognizing judgments incorporating foreign arbitral awards in Nigeria, and therefore a judgment creditor that intends to recognize a judgment in Nigeria should solely utilize the provisions contained in the Arbitration and Conciliation Act. Thank you.
Thank you, Dr. Ijegwe. Thank you for that very presentation. Two things. There is in this area of the law, and our case law is very well developed in terms of recognition of foreign arbitration awards. But I agree with you entirely that the laws you're using are a bit archaic. I seem to bring them with modern times. There's need for us to amend those laws. Dr. Yekini, I think the floor is yours now to speak on jurisprudence of personal jurisdiction. Dr. Yekini, please.
Yeah, thank you, sir. Good evening, everyone. My Lord Honorable Justice Abiru.
Good evening.
I want to share the next few minutes with us on the concept of personal jurisdiction in Nigeria. Can you hear me, sir?
Yes, we can hear you.
Yeah. So this, perhaps for non-PIL experts who may wonder what personal jurisdiction means, it's also called impersonal, jurisdiction or action, and these are cases filed in court by parties for the determination of legal rights, amongst themselves or between themselves, as the case may be. So this is a concept that is of interest to most PIL scholars from Nigeria, because it is highly misunderstood by Nigerian courts. I know for sure that my Lord Honorable Justice Abiru has written a paper on it. Professor Olani and some of the people, some of the members of the audience, Professor Bamudo has also written something on it. So, and we need to take this concept seriously, in my view, especially now that Nigeria has joined the Continental Free Trade Agreement. We expect to see increasing number of cases from outside with foreign elements coming into Nigeria, where parties have no connection with Nigeria except the fact that maybe the defendant resides in Nigeria. The first issue I'm discussing is the normative framework for personal jurisdiction. And this is very important, although I will not be able to go into all of them, as Professor Opong mentioned earlier on. Most of our judges, as far as this part of the world is concerned, we don't really engage with theories or underlying policies for certain decisions. We just pick, cases cited or decided earlier on, then we just apply them straight away without really considering what are the theoretical background or underlying policies behind these cases. Why should a court exercise jurisdiction over a subject matter that has no connection with or which the cause of action arose outside the jurisdiction of the court, or which the cause of action arose from another state. Now, for instance, you have an action before Lagos High Court and the cause of action exclusively arose or belong to Ogun State. Why should the Lagos High Court exercise jurisdiction over a matter from Ogun State? That is basically what we're talking about. We can have it in two situations. You can have personal jurisdiction over people who are residents within the jurisdiction of the court, and you can have a court can exercise personal jurisdiction over non-residents. I'll take the first one. We all understand the concept of sovereignty, which simply means that a state exercises maximum control over things and people within, the confines of that, the territory of that state. And that means that the court of the state, because the court is an agent or trustee of the state, so the court exercises the power of the state. So under the traditional common law, once you find yourself within the territory of a state, and of course that is also acceptable under public international law, the court of that state has maximum control over you, and any cause of action can be filed against you in that state. Because you belong to that state, the court has jurisdiction over you, over your property, and any cause of action, irrespective of where the cause of action arose, can be brought before that court, and the court can exercise jurisdiction over you based on the doctrine of effectiveness, because it is considered that the best forum to sue a defendant is his residence, because you can easily enforce a judgment against the defendant where he has his assets or where he's ordinarily resident. And there is no dispute as to this concept all over the world, except in Nigeria, where the court, as we will soon see, where the Supreme Court has held that the jurisdiction of a court is territorially limited. And what they mean by that is that if a cause of action did not arise in a state, that state cannot exercise jurisdiction. For instance, if you commit a tort, or if a tort occurred in Ogun State, which is a neighboring state to Lagos, you cannot sue over that cause of action in Lagos State, even if the plaintiff and the defendant are residents in Lagos. Basically, what the Supreme Court is saying is that both parties have to travel down to Ogun State, or even if it's as far as Borno State, you have to travel far to Borno State to litigate that particular dispute. And by extension, it means that if you transact business in Ghana and you think Nigerian courts, they have a good case management or procedural efficiency, they have it, and you want to have your disputes resolved in Nigeria, even though parties are from Ghana or one of them is from Nigeria, but they transacted business in Ghana, you cannot choose a Nigerian court. Dr. Okoli will soon will speak about that, so I won't go into that. So that's just the implication of that decision from the Supreme Court. But that is, a problem here, because you cannot, what they're saying is that a court cannot exercise general jurisdiction. And by general jurisdiction, we mean that jurisdiction over that person, irrespective of the subject matter or irrespective of, where the cause of action arose from. So that is what we call general jurisdiction, and that is what the Supreme Court has said. But that would be strange to those who are from, who are not from Nigeria, in common law and in almost all parts of the world. The second aspect is jurisdiction over non-residents, and we don't really have issues here.
Dr. Yekini, you think you're rounding up now?
Yes.
I think you're rounding up now, please. Yes.
Okay. So our position is that this particular interpretation of the Supreme Court is very wrong, based on the concept of sovereignty, the concept of effectiveness as we have under the common law, and we have cases from Nigeria, especially the one given by the moderator himself, Honorable Justice Abiru, in Mohammed Ajingi. This is I would say the most significant case in Nigeria that is very explanatory and expository on the concept of personal jurisdiction. And my Lord spelled out the jurisdictional basis for exercising personal jurisdiction over defendants who are resident in your state, even if the course of action has nothing to do with the forum. So I'll just put it here. My view that this is a concept we need to take seriously, because as we move into the international scene vis-a-vis the continental free trade, we expect to have more cases with foreign elements in Nigeria, and we cannot undermine the concept of personal jurisdiction. And I'm saying that the Supreme Court has to reconsider this decision in Dairo and CBN, which holds that a court cannot exercise personal jurisdiction over a defendant if the course of action or if that forum has no connection with the course of action. So I think I will stop here. If there is time, I can say one or two things more.
Thank you, Dr. Yakini. Thank you very much for that exposition. Thank you, very grateful. The issue is, the issue of privatization law, Commons of Law Nigeria, is a developing concept. The case of Dairo you referred to, and the issue of privatization was not considered at all, was not presented to the court at all. It was dealt with like a normal, the interstate element of the case was not pointed out. So the court dealt with it basically as a regular court action. Dr. Okpong made a very important comment when he was talking about the need for the scholars, the academics who write articles on privatization law, to make them available to the judges. I've received some of the messages, some of the articles that have written by Dr. Effiga and Dr. Okoli over the past few years on this area. I'm sure that with time, particularly with this African something I was talking about, there's a need for the court to develop very robust principles on this, and I'm sure it will be done. Dr. Okoli, I'll invite you now to speak on the choice of court agreements in Nigerian jurisprudence. You have 10 minutes, please. The floor is yours.
Okay, thank you very much, my Lord, Honorable Justice Abir. And thank you very much, everyone, for this coming to this occasion. I'll be talking about approaches to the interpretation of choice of court agreements in Nigeria. And this will be the nature of the discussion. I would introduce it. I'll talk about the issue, the problem. Now I'll go into the meat of the discussion, approaches to the interpretation of choice of court agreements in Nigeria. And then I will conclude. I'll try and be brief as possible. So a choice of court agreement is an agreement to litigate in a particular forum, So it could be, for example, in one forum, which is called an exclusive choice of court agreement, where both parties are limited to one forum. It could be in more than one forum, which is a non-exclusive choice of court agreement, or it could be that one party is limited to one jurisdiction, while the other party can sue in multiple jurisdictions, which is, for example, which is called an asymmetric choice of court agreement. For example, where the creditor can sue the debtor in multiple jurisdictions, whereas the debtor is limited to only one jurisdiction. Now, I have to make it clear that a choice of court agreement is not the same thing as an arbitration agreement. Although they are both forum selection clauses, they are not the same thing, I need to make this clear because you see some Nigerian judges applying the same principles to arbitration agreement, to choice of court agreements. Choice of court agreement is governed by common law in Nigeria, whereas arbitration agreement is governed by Arbitration and Conciliation Act. Another thing to note is that a choice of court agreement is not the same thing as a choice of law agreement. So, for example, the party can decide to choose English law to govern their contracts, whereas they can decide to choose Nigerian courts as the forum to litigate. So they are not the same thing. So the fact that you've chosen a particular court doesn't necessarily mean that this law is going to apply. They are distinct. So, but now going to the issue is, how do we classify a choice of court agreement? Is it a contract or is it something else? How would you really classify a choice of court agreement? Now, this is a very important issue because when we go to the next slide, we discover that Nigerian courts have reached inconsistent definitions on what's on the issue of choice of court agreement. So how do we really classify a choice of court agreement? Is it a contract or is it something else? Now, this is the main issue. This is why I'm raising this issue. In the year 2020, just in the year 2020, just last year, the Nigerian Court of Appeal reached 3 inconsistent decisions on choice of courts agreements. The first was Kashumi and UBN, where the court held that the choice of court agreement wasn't valid, that the parties didn't really make a choice of court agreement in favor of Benin Republic. So technically, the court didn't enforce the choice of court agreement, but the court applied what I would describe as a contractual approach, that the parties did not agree to make a choice of court agreement in favor of the court of Benin Republic, another African country. Then we had another decision by the Nigerian Court of Appeal in Damak Star Properties LLC and Profitel Limited, where the Nigerian Court of Appeal strictly enforced a Dubai choice of court agreement. So it just treated the choice of court agreement from Dubai as a contract and enforced it strictly. Then in November 2020, the Court of Appeal made a U-turn again and refused to enforce a valid choice of court agreement in favor of the Commonwealth of Virginia in the United States of America. Even though this choice of court agreement was valid, there was no dictating elements. The Nigerian Court of Appeal declined to enforce this choice of court agreement. Now, what are the approaches to the interpretation of choice of court agreements in Nigeria, which is the meat of the discussion? Now, if you look at the decisions, you discover that there are 3 different approaches to the enforcement of choice of court agreements in Nigeria. The first is the ouster clause approach. Now, if you look at, if you study constitutional law in Nigeria, you discover that during the military regime, the Nigerian judges regarded clauses created by the military ousting jurisdiction of Nigerian courts as ouster clause and interpreted it narrowly. And some Nigerian judges have tended to give choice of court agreements this same treatment as an ouster clause. For example, in the first case of Bentujo and Campagne Francais de l'Occidental, the Nigerian court refused to enforce a French choice of court agreement. In Allied Trading Company's case, it refused to enforce a Chinese choice of court agreement. It regarded such clauses as ouster clauses. In essence, it regarded such agreements as illegal, as ousting the jurisdiction of the Nigerian courts. Then in Sona's case, you discover that the Oputa JSC, a Nigerian Supreme Court justice, stated that Nigerian judges should guard their jurisdiction jealously, and any private contract that chooses a foreign forum should be regarded as an ouster clause. Although if you look at the majority of the Supreme Court's decision in this case, they actually held that a choice of court agreement should be enforced except the plaintiff advances strong reasons to the contrary. So Oputa's judgment was a separate opinion in this case. So this Oputa's statement was actually applied in ABU and BTL, which I actually mentioned, where the Court of Appeal regarded a choice of court agreement in favor of the US as an ouster clause. Now, the second one is the Brandon test. The Brandon test is like what you call a forum non-convenience approach, where the court would only refuse to enforce a choice of court agreements where the plaintiff advances strong reasons to the contrary. Now, this approach has been applied by the Supreme Court once in Sona's case. The plaintiff advanced strong reasons to the contrary by stating that the action will be term barred in a foreign forum. So the Nigerian Supreme Court did not enforce the choice of court agreement. But if you look at the other case, Nika Fishing Company and Lavina Corporation, the plaintiff was unable to advance strong reasons to the contrary. The plaintiff did not even file a counter affidavit. So the court strictly enforced the choice of court agreement. So this is actually a forum non-convenience approach to the enforcement of choice of court agreements. And I call it the Brandon test because it was an English judge called Brandon that developed this approach to the enforcement of choice of court agreements. Now, the next one is the contractual approach. Now, the contractual approach is actually an approach actually favored in the EU and maybe the Hague 2005 Convention on Choice of Court Agreement. This approach just treats a choice of court agreement like an ordinary contract. You know, like Professor Adrian Briggs would say, a choice of court agreement is no different from an agreement to sue or an agreement to sell goods, you know. And if this approach has been accepted by the Supreme Court, obiter dicta, in Con Oil and Vito SC, where some Supreme Court judges actually adopted the contractual approach, although the main issue in that case was the enforcement of foreign judgment, but they actually adopted the contractual approach. And if you look at
rounding up now, please.
Okay, if you look at Kashmir and UPN and Damak Stars, the contractual approach was also adopted as well, you know. Although in Kashmir's case, the court did not enforce the contract, but in Damak Stars, they enforced the contract by applying the contractual approach. So I'll conclude. So in order to avoid this inconsistency, Nigerian courts need to define what a choice of court agreement is, you know. And secondly, Nigerian courts need to be made attractive for international commercial litigation. If this is done, you know, it will be easier for Nigerian courts to enforce choice of court agreements because you have other courts enforcing Nigerian choice of court agreements. And finally, we need to consider ratifying the Hague Choice of Courts Convention 2005, you know, and this also gives effect to party autonomy on the enforcement of choice of court agreements. So I'd like to thank you very much for listening.
Thank you, Dr. Koli. Thank you very much. Now, one thing that becomes very obvious from the presentations by the three speakers is the need for the NGPIL to engage with the Training Institute for Judges on bringing about some of these issues to their attention. A lot of the decisions have been guided at different times by different approaches. Some have been defensive, like you said, to defend the Nigerian, this integrity, sovereignty issue. Some of them have been determined by that. But what you find out that gradually and consistently, there is a move away from this sovereignty, and you cannot take away a judicial issue now to the Brandon test, like Dr. Koli said, and the issue of holding the parties liable to the contract that they've given. But all in all, my suggestion to NGPIL is to please engage the Nigerian Judicial Institute, which does the training of judges, and engage them and actually organize training programs for judges in this area. Comes of laws is not your general everyday legal issue. It's a specialized division. I mean, I got interested in it when I did it in my master's level. That's how I developed a lot of interest in it. And as even at that time, there were many decisions that did not understand the common law situation. So you need to, honestly, as a matter of policy, engage the NGI to discuss with them, organize training for Nigerian judges on this area. Because at the end of the day, the better the Nigerian courts get, the better the practice of constitutional law in Nigeria also gets. I think with this, I will ask for comments, questions from people who have any questions or comments. Any questions, please?
There's one from Soji Elias.
Hello, very good evening. Yes,
yes.
Just a couple of quick comments. Hello, my Lord. Good evening.
Yes, how are you? How are you, my brother? Yes.
Very well, and good evening to everybody else. Ben Gabamodu, I've seen a few other names as well. Just a couple of quick ones. The first one is to do with this matter of choice of court or choice of jurisdiction differentiated from arbitrations. Yeah. I think that what looks like erratic adjudication is probably underscored by something in the nature of public policy or judicial policy. Now, if the choice of court clause or agreement in favor of Dubai is upheld, where one in favor of Benin is not. I think we're looking at the very early stages of attention to public policy in explicit terms in the Nigerian conflictual landscape, or judicial policy. The other one is to do with this thing called forum shopping. I think I will go with Dr. Okoli, where he encourages the promotion of the Nigerian legal system, because that is what will give us access, meaningful or consequential access to things like the HCCH. The man from LASU had underscored forum shopping as something reprobate. It is not. If you have a better option, you make that, you choose in favor of that better option. Not only is it circumspect or worthwhile human nature, it is also sensible. Lord Denning, all of it simply echoes Lord Denning way back. What is wrong with forum shopping? What is wrong with the English judicial system? Of course, come and shop here. Let's not deprecate forum shopping unnecessarily. If it is unprincipled or without scruples, yes, then we have a problem. If it is not, full steam ahead. We become more competitive, especially in the early stages of this African continental free trade area and so forth. Dr. Okoli, thank you very much for bringing this forum, chat group to my attention. I think it is set to make a difference, not least with the likes of my Lord Abiru.
Thank you, Mr. Lyles. Thank you very much. I think the challenge is the lack of consistency. If there's consistency and this is where we are going, we know it's the judicial policy, we know it's a public policy issue. It is the rigmarole in and out of different concepts that's causing the confusion. Thank you very much, Mr. Lyles. Mr. Bamodu, you have a question or a comment? Mr. Bamodu.
I'm sorry, I was muted for a minute. I hope you can hear me now.
Yes, we can hear you, yes.
Thank you, Your Lordship. And, first of all, just greetings to a lot of names and old friends and seniors. And, I'm so glad Soji remembers me, which of course he must do, because we go back a lot. Just a few comments. First of all, to echo what has been said already, I think right from the beginning about engagement with the relevant people, especially the judges in this instance, between, yes, the NGPIL, but I think much more broader, those of us, all scholars interested in private international law, specifically engaging the judges at every level, well, say, superior courts, high court onwards, up to the Supreme Court, and most importantly, the Supreme Court. Another general comment, one thing which sort of saddens a little bit is that our current courts, especially the highest court, the Supreme Courts, seem to be sort of lacking in awareness of historic decisions of the courts itself, especially the Supreme Court. A lot of these things were settled accurately by the Supreme Court a long time ago, but now they are being unsettled by decisions which effectively apply in curiam because they were made without references to decisions where the Supreme Court had settled them. Take, for example, the issue of personal jurisdiction that Dr. Yek was talking about. The accurate position had been set out as early as 1977, even older in Benson and Ashiru or in Dayo and Ogunaya.
Yeah, Mr. Ashiru, yes.
Yes, as long ago, but now the courts are ignoring them and then going and then unsettling them with gross inaccuracy, which is very, very sad to see. So that's just a general point about that. Now, going to a couple of specific things. First, about the arbitration. I think the conclusion that Dr. Ojiegwe reached in the end is probably correct, that it is not wise, at the least, to seek to enforce arbitration awards under the statutory regimes. For a start, the Arbitration Act, which implements the 58th Convention on Enforcement, makes it so much tighter to challenge. I know our courts can implement them in funny ways, but it makes it so much tighter to challenge arbitral awards, especially on the merits. If you were to do as a regime or a system of pursuing, enforcing them under the statutory regimes, one, you are going to open greater opportunities for challenging the awards and even potentially challenging them on the merits and relitigating things which had been settled in awards. So it's extremely dangerous. It's a question of operating as properly as possible. The current Arbitration Conciliation Act, I insist 1988, I refuse to say 2004. And then, of course, the amendment that is envisaged, or rather the new legislation that is envisaged, if it does come about, rather than taking the risk of going back to the statutory regimes. And talking about the, specifically again, in personam jurisdiction, there again, another important point was made earlier on by two different commentators, the earlier rapporteur and then, one of the presenters, about our judges being made to understand the connections between the rules and underlying policies and principles and reasons behind why particular rules are the way they are. That will facilitate their understanding, but also interconnections between rules. So where, for example, there's a concern that in personam jurisdiction means an out-of-state, a cause of action that arose out of state is to be heard in a different state, there are other rules that can deal with it. You have, for example, the principles of forum non-convenience can deal with that. The fact that one state, a cause of action arose in another state.
We need to round up quickly, please.
Okay.
Please turn around.
I'd better stop. I could go on and on. Let me stop.
Okay.
I think that's
Thank you very much. One thing that is obvious is there's a need for continuous education, continuous improvement, continuous engagement between the scholars and the Nigerian judges in order to facilitate the works of all practitioners of conflict of laws. And it's a massive growing area of the law. And the earlier the judges are on top of it, the better it is for all the practitioners. I think with this comment, I will say we come to the end of the second session. I'll hand over back to the chair to invite Dr. Olaniyan for his final comments. Dr. Momo, please.
Thank you. Thank you very much, Lord Justice Abiru, for assisting with this session. Yes, we are coming to the end. I wanted to say that Professor Opong had to drop out and he sent his apologies. Before I pass on to Professor Olaniyan, yes, really, I just wanted to give my unreserved gratitude to everybody here for joining us. We had 132 registered participants. Thank you to the diehard or the ones that are still on right now. Thank you for staying to the cause. I'm sure that taking your time this evening to hear from us is showing your own commitment to wanting to see change in private international law in Nigeria. Professor Olaniyan, I'd be most grateful to hear from you to conclude this event. Thank you.
Good evening, ladies and gentlemen. I hope you are hearing me. Hello?
We can hear you, Prof.
Yes.
Yeah. Well,
but we can't see you.
Oh, okay.
Mm-hmm.
Let me make it. Sorry, I'm using my phone. Something went wrong with the laptop.
Okay, all right.
Okay, can you see me now?
We can.
Okay.
We can see you now.
Yes, please continue.
We can see you.
Okay. Well, I want to start by echoing I think it's an Ugandan proverb that talked about the first best time to do something probably was some 40, 50 years ago, but the next best time is now. I congratulate the NGPIL for arranging something like this, and I hope that it is going to be a continuous activity, not something that would, after going on today, would not occur again. The time had long been due for somebody to be calling the attention of our judiciary to, I call it, unforced errors. When I first started reviewing the court judgment, I used to talk about switching off. It looks like our judges just switch off completely. And when they switch off, they give all manners of reasons. For example, in the Union Bank case, I recall the Justice of the Supreme Court saying that because Nigeria is a federation and that it is usual in a federation, he even went on and cited Section 234 of the Constitution, talking about how judicial powers are divided between the states and how you cannot take the matter of one state to another and all of that. And I said, wow, what a reasoning. Nigeria has been a federation since 1954. And despite Nigeria being a federation since 1954, we had decisions. A lot of people cite Benson and Ashiru. I think the most apt decision to correct the Supreme Court is the case of NPA and Panapina War Transport. The NPA and Panapina War Transport was a case where the lower court misunderstood the issue to be in them because they were talking about collection of rent in respect of property in Warri, and so because landed property was involved, he talked about in them and all of that. This same Supreme Court corrected the Lagos High Court. This same Supreme Court said, look, somebody is asking somebody to pay him money. He finds the debtor in Lagos. Lagos is the court with jurisdiction. I think that is the highlight of impersonal jurisdiction. You're asking for somebody to perform an obligation. You find him in a state. You have sued him there. The court of that state has jurisdiction. But so I used to ask my students in 1973 or 74, when MP and Panapina War Transport was decided, was Nigeria not a federation? Then the Supreme Court will go on to say, you see, there was military hangover, there was this, there was that. I say, what type of logic is this? Military hangover. Did the military convert Nigeria to a unitary state? I will ask my student, I will say, look, in 1974, will anybody mistake Warri to be the same or within the same sub-sovereign as Lagos? Clearly, there is a lot of switching off that our courts do. There's even another issue that we are all not addressing. Under enforcement of foreign judgment. Really, should any Nigerian court enforce any judgment on the basis of the 1961 Act? It's like putting the cart before the horse. If anybody understands the regime that the 1960 Act was trying to establish, the person will see clearly that until the Attorney General does what is expected to do, we are stuck with either using the common law to enforce foreign judgment or, where applicable, enforcing foreign judgment on the basis of the 1922 ordinance. But who will tell the Supreme Court? I've seen Apex Court judgment, Court of Appeal and Supreme Court, where the Nigerian court were allowing judgment from the United States of America to be enforced by legislation. You won't find that in any of the Commonwealth countries. So we seriously need to be doing this regularly. And like my Lord Justice Abiru said, our real audience ought to be the judges. Our real audience ought to be the judges. A lot of people think this our subject is abstract. What abstract? What are you talking about? We will cite you sections. We will tell you that the basis of saying that the court has jurisdiction is section 10 of the High Court law. We will give you old cases. See, you say abstract. No, we are not talking abstract. It is just that the judiciary is refusing to understand us, and they need to understand us. So I congratulate you for making this possible. and I urge you to sustain it. And I really, really would want to be more and more active on this group in the future. Thank you very much for inviting me to talk. I am impressed. I'm highly impressed. My Lord. My Lord, I commented about your Lordship judgment in Nigeria and Mohammed. I say, you see, this is what you get when a teacher of conflict of laws become a justice of the Court of Appeal. Unfortunately, I was waiting to see when the Supreme Court will say somebody has taught us what we should do. But where? You still read the judgment, they go up and down. Oh my God.
Thank you very much, bro. Thank you.
Yes, thank you. Thank you very much, Professor Olaniyan, for that riveting conversation, and also, of course, pointing out the frustrations within the system, which we don't want to be echoing to. We obviously are a group that are trying to stay positive, but we are very, very aware of the obstacles and challenges that are ahead of us. Thank you again, I think, to the panel and to our audience. I don't have anything else to add unless anyone else does, but simply to close the event and thank you for spending your evening with us tonight. Thank you.
Thank you very much.
Thank you.
All right. Bye-bye.